section 5, powers. The powers of the municipal council. It again refers you to section 9, natural person again. Section 6 grants the municipal councilors the authority to expropriate. That is also part of acquiring. Section 7, that is more criteria in regards to the province. Section 8. Section 8 states that municipal councilors may exercise their authority in broad and liberal terms for the management of its, there's that ITS word, its, meaning the corporation's affairs. Not your private affairs. This is a corporation. Section 9, we've already discussed. Rights, privileges, authorities, and capacities of a natural person. Section 10 and 11. That is the jurisdictions of power. So section 10 and section 11, subsection 2. Section 4 of subsection 2, as Jeff alluded to earlier, states, a municipality may pass bylaws to acquire assets to exercise its authority under the Municipal Act or any other act. So, there's no definition in that act for what is a municipal property asset. So you go to Regulation 59906 and lo and behold, there is the definition of municipal property asset. It means lands, equipment, or goods. So, for the municipalities as a corporation to exercise its authority under the Municipal Act or any other act, they must acquire municipal assets to do that. Like we said, that's land. So that they can implement economic development. So that they can create new subdivisions. If they want new subdivisions created, they have to acquire the land if they want to plan for that subdivision. Think about it. As it stands right now in Ontario, we have development fees right through the roof. We have extortion actually happening, and theft, and I will use those words. Because municipalities are saying to developers and people, you must give us some of that land for a park, or we want to be able to designate that as wetlands. And if you don't do that, you aren't going to get that permit that you have come to us to get. Now, we received a letter from a member who had actually received a letter from the chief building inspector in his area. And in this document it stated, and this, he said, came under legal advice from the legal department of a municipality. You have made application for zoning, so you recognize our authority. So if he had not made application, they actually did not have any authority. Okay? But if he had made application, they would have charged him. Everyone needs to get a copy of the Criminal Code of Canada, because as it stands right now, as of July 2013, in British Columbia, that western group, there is an application or an action in the courts right now And this is what I am actually trying to stop by doing these municipal seminars. I'm trying to stop councillors and staff from being sued and from being charged under the Criminal Code of Canada. Because that's exactly what's happening in British Columbia as we speak. Every member of council and the staff members that were involved with demands for permits, for trespass, for making claim, for failing to return properties, are all being charged. That can happen anywhere. Most of the councillors I have met, particularly the ones that are landowners, they are doing the very, very best they possibly can. I have one deputy reeve. If there's a bylaw that's going to be passed, that deputy reeve contacts me. What do you think? Well, I say, I'm not a lawyer, I don't give legal advice. She says, I know that. What do you think? I tell her what I think. I said, but you can't use that. And she said, okay. So then she goes in and she demands a recorded vote. So that if there are lawsuits launched, she can at least try to have some form of protection for herself. So now it's gotten to the point that the rest of council is saying, so, which way are you voting? And why? This is the whole thing. She gets it. She understands that the municipalities are merely council. They are merely a corporation. They are merely a board of directors. There is no such thing under the Municipal Act as warrantless entry. There is a right of inquiry, but there is no warrantless entry on private property. The only statements in there are if there is forfeiture for non-payment of property taxes, so that they may actually, I think it's section 462, but don't quote me on that one because it's a big act, but they only have the authority to inspect before it goes to the sheriff's auction. That's what that is there for. That's it. Every other bylaw is to be implemented on public properties. So, why would it be, or why would anyone in this room think that they have control over your private property if they have to actually get your permission, if you live in town, to hook you up to sewer and water? Under the building code, if you own the property, okay, and it states right in it that under section 8.3, the person who is supposed to be going and getting the building permits is not the private property owner. It is the third-party corporation who is the developer. Because the building code was established as a warranty by the province, a one-year warranty, and it's called the Ontario New Homes Warranty Act. And now it refers you to Tarion. But if you, as a private property owner, are number one, building it yourself, number two, not infringing or injuring your neighbors, number three, are not seeking any warranties from the province, which, by the way, Tarion warranties are not really worth the paper they're written on. Ask the couple in Collingwood, two of them actually. One house is a tear down, the other one, they are getting no money for all of this water that's coming into their basement. This is the whole thing. Section 35 and 35.1 of the building code. If the owner of the property is supplying all of the materials, if he is going to be the engineer on it, he is the one that is responsible for that house, for that building. The reason Terrian was set up, and the reason that the Ontario Home Warranties was set up, and the reason that the building code was created in the first place, was because the crafters, the people that used to be the master craft carpenters, that used to take so much pride in their work, stopped doing that. Apprenticeships were pretty well done. Actually, you want to know something? My uncle was the first certified master carpenter in Ontario, right after World War II. Now, he was excellent because my dad and him built my mother's dream house for her. The main floor was like 2,800 square feet. It was 3 floors high. It had this great big huge honkin' living room with hardwood floors, and don't you spill anything. That entire house, that whole structure, was out 1/8 of an inch. Do you think you're going to get that today? And I'll tell you how extreme this has gotten. They're telling people now they have to have, for their own private homes that they're custom building themselves, even though they're subcontracting out to other entities, they have to have an occupancy permit. They do not. That is for social housing. That is for rental. That has nothing to do with your private homes. And how do I know that? Because my brother built a house, and the building inspector came along, and we've had this discussion, and he says, well, you can't move in until you get an occupancy permit, and we're going, really? So what are you going to do with all the 100-year-old farmhouses then? They never had occupancy permits. The other thing too is, did they need building permits for Queen's Park? For the Parliament buildings? Because if you all are required to have building permits for your private buildings, I'm thinking that maybe other entities do as well. So that's kind of the condensed on the building code. So, back to the Municipal Act. We got to 10 and 11. Section 10.6 explains the different boards of the municipalities. You have social housing. You have the heritage committees, and no, they do not have any authority over private property, and if anybody says they do, read the Act. You should go to Part 5 of the Heritage Act if you're having difficulties. Under Section 5 or Part 5 of the Heritage Act, it states that municipalities may designate an area, a district, a heritage district. You go through all of that. If you have problems with it, you go to this one or you go to that one, but then you get down to Section 45, which is the application of that section of that act. Section 45 refers you to Section 36 through to 39. Okay, so this is where it is stated that the municipalities must, A, enter into an agreement with the private property owner, and the private property owner must be willing and knowing all of the criteria that is laid out in these contracts, which are these agreements. 2, they can enter into an agreement with the Heritage Trust. Or number 3, there can be an expropriation. So then you get into Section 45.1 of the Heritage Act, and this is where Section 15.1 to 15.8 of the Building Code comes into play. That is municipal property standards. You're all going, but municipal property standards bylaws are causing us such terrible problems. Well, municipal property standards does not grant the municipalities the authority to create municipal property standards bylaws for private property. Section 15.1 to 15.8 is limited by Sections 1.2 and 1.1 of the Building Code. This is actually what I busted municipal affairs on in regards to seeking information. Because then, if you go down to section 35 of the building code, municipal bylaws, and that refers you to section 3 and section 10. And 35.1 of the building code states that any regulations made by the conservation authorities are not considered regulations under the Legislation Act of 2006, under the building codes, because all it really pertains to is new sewer, septic, and water. And it's sewer and water. And you actually all, under the Municipal Act, under the building code, under the Conservation Authorities Act, do not have to apply to the conservation authorities to put your own septic and well in. Because Section 21 of the Conservation Authorities Act grants the conservation authorities the authority to enter into agreements with the private property owner. Section 28 are the regulations that they can lay down in those agreements. The only application thing that happens with the conservation authorities is under the easements or covenants that you have entered into. I know I have a copy of that agreement. The reason that this is all happening is, I'm going to tell you about a meeting I was at last weekend. I ran into one of the most incompetent agents for the conservation authorities. This girl was young. She was a very tall, leggy blonde, beautiful big blue eyes, drop dead gorgeous. And I can get away with saying this, she was a real blonde.
Can I have a phone number?
I didn't say one word at this entire meeting, but other people did. They asked her, well, can you explain to us about Section 21? Now, you have to understand something about this girl. I got to make this clear. This girl is the permitting and enforcement officer for this conservation authority. She's the one that issues the permits, and she's the enforcement officer, okay? She's to know what you're doing wrong. So, a woman in the audience asked her, could you please explain to us about the agreements under Section 21 and the connection between Section 28 of the Conservation Authorities Act? Her response was, I don't really know that, but if you could contact my office, I would gladly get back to you. This is the enforcement officer. Then another fellow asked her, when were the conservation authorities created and what is the mandate of the conservation authorities? I'm sitting there, I almost busted out laughing, but I didn't. I controlled myself. Because this is what she said. The conservation authorities were created because of Hurricane Hazel and were to save lives. This is what we, the people, are dealing with. Like, I have it right from the Hansards and I have it right from the legislation that the conservation authorities were created to eliminate flooding and to stop erosion. That's it. They were created, actually, 1932 was the original for the Grand River Valley Commission. In 1938, they repealed that act and they created a new one for the Grand River Valley Conservation Commission. And it became actually the standard for the Conservation Authorities Act that was created in 1946. It was never, ever, ever to infringe on private property. If they had to create structures, meaning dams and reservoirs and so on and so forth, they had to expropriate the land. They had to buy it. Their jurisdiction is limited to what belongs to the conservation authorities. That's it. Remember, what was it, back in the 70s, 80s? They wanted the 80s. They wanted to pass legislation allowing conservation authorities and the provincial parks to be able to say this is a liquor-free weekend. Remember that? And on the long weekends, nobody can drink in the provincial parks or in the conservation parks. Yeah, I know, boo. But anyways, there was a huge discussion on this in Queen's Park. Because the conservation authorities could only regulate for what belonged to the conservation authorities. And it was the thought that if they went forward with this, that the provincial legislature might be interfering with the regulatory authority of the conservation authorities in their own parks. Yeah. Because the conservation authorities can regulate what belongs to the conservation authorities only. The same as you can only regulate for what belongs to you on your private property. So, now we have this new thing out, and it's called the Farmland Trust. I am not happy with this. And I'm going to refer you all to the Conservation Land Act. Because under the Conservation Land Act, when it was created back in the late 80s, early 90s, this act was created because they wanted to recognize people who were doing their utmost to be environmentalists on their properties. There were huge tax breaks under this. Huge. And the conservation authorities were quite happy about this because their property that couldn't produce any revenues actually got a 100% tax rebate. And then Bob Ray got into power. Now I'm going to explain to you about these trusts. These trusts are created under the Conservation Land Act. You, as a farmer, can actually enter into an agreement with this trust, and this is a forever thing. But I want you to be fully informed, because they are not fully informing you about these agreements. Under the Conservation Land Act, each and every agreement can be transferred to some other conservation body. And it's not going to remain just with the trust if they don't want to. It can be transferred to, or assigned, I guess is the word they use, to conservation authorities, to municipalities, to the Queen and Right of Ontario, or to the Queen and Right of Canada. So the Farmland Trust has also made the statement, oh, these agreements will last forever. Wrong again. There were all kinds of agreements created from 1988 up to 1993. Bob Ray bankrupted Ontario, and he canceled that. Do you think those agreements still stood after Bob Ray canceled the tax rebates that people were getting in regards to those properties? So government arbitrarily changed those agreements. So now they're back at it again. But my big question to every person in this room, the province of Ontario, and if you go to the Ministry of Natural Resources website, has control over and owns, or has administrative control and receives the revenues from 87% of the landmass within the geographical boundaries of this province. That in what was it, 1998 or 2003, that was 937,000 square kilometers. There is only 13% privately owned and controlled in this province. So why are they needing conservation trusts? Why are they needing farmland trusts? And by the way, if you're a farmer and you want to launch or register a covenant or an easement against your property that runs with the land, you can do that yourself. And you have the absolute control, and that covenant will keep that as farmland forever. You don't need to enter into agreements with some entity that may assign all of those property rights to some other entity. You have the authority, the right to do it yourselves. And if you are so inclined, understand that the value that you have on that land will decrease exponentially if you do. And if you enter into these farmland trusts, exactly the same thing will happen. Remember how farmers, we want to save farmland in Ontario. Don't get me wrong. I personally feel that farmland is very important. The majority of the Landowners Association do. So, my thought process is, if the province of Ontario is so darned concerned with keeping farmland protected, why are they not opening up some of that 87% that they have for development? Why are they trying to push all of the people into Toronto, St. Catharines, Hamilton? Why are they not opening up the north more? There's something systemically wrong in this province. And now we're back to the municipalities. Because they are abusing our municipalities. They are abusing the councillors. They are abusing the people. Because they are doing indirectly what they cannot themselves legally do directly. And it's a standard of law that they can't do something indirectly that they cannot do legally directly. So they are placing our municipalities so far in debt that the municipal corporations are trying to come up with any and every viable means to stay afloat. And this is wrong. Everybody thought that Mike Harris did a terrible thing by downloading so much stuff, right? Dalton McGuinty comes along and says he's going to upload it. Well, not very much got uploaded, but a whole bunch more stuff most certainly did get downloaded. And then there are the carrots for our municipal councils. We will give you X amount of dollars in a grant if you create that library that's environmentally friendly with the grass on the roof. We will grant you a certain amount of money for you to tear up a perfectly fine main street and put in an environmentally friendly main street. We will grant you X amount of dollars if you create a new community center, even though it would only cost you $90,000 to fix up the old one. The new one's going to cost you $10 million, so we'll give you $2.5 million, and you'll have to get the rest from your ratepayers. And this is what's happening, because the staff is very, very good at hunting down these grants, but staff isn't thinking 5 minutes down the road as to who's going to pay for the extra 50, 60, and 70% of the costs of that work. This is the whole problem. We have staff that deal with, as Cindy said, their one little thing. So a planner will deal specifically with the Planning Act. Will completely ignore the fact that under the Municipal Act, They have to own it before they can create bylaws for it. So then you have the chief building inspector. He deals specifically with the building code. Do you know that with the new regulations in the building code, the new building code with all of the regulations is 1,853 pages? Do you think your building inspector actually knows that entire act? But I now know what the definition of an outdoor pool is. Yes. An outdoor pool is, are we ready? A public pool that is not indoors. So why are you all getting licenses and permits to put pools under the building code in your backyard? Is it going to be open to the public? Are you going to be paid by the taxpayers of your municipality to let them use that pool? I'll tell you, it was quite the learning experience reading through that, and I was pretty blurry-eyed by the same time I was done. But I do know more about sewer and water systems than any woman should. That's the problem in this province. Our municipal councillors, and actually even our staff, even though I have very little respect now for planners. I was asked to speak by the University of Guelph at their Rural Land Use Conference this past spring. And it was a huge honor. The panel that I was with, Elizabeth Brubaker was there. She's an expert on expropriation. Glenn Fox was there. He's a professor of agricultural economics. He knows more about the Niagara Escarpment and this whole initiative than most people should. His words, they knew that the Niagara Escarpment plan was going to end up costing $3.2 billion back in the 70s. They knew they couldn't afford it, so they just said, go ahead, do it, and we'll ask forgiveness later. Yeah. The Niagara Escarpment Commission, the plan, is for what belongs to government, not your private property. Now Bob Mackey, he's still doing the fight. And that's because they told Bob Mackey he had to make application. So they're of the opinion now that Bob Mackey recognized their authority. Yeah. Floodplains. I got a good one for you. Conservation authorities are going around saying you can't build there, that's a floodplain, that's bad. Did you know that I have in my possession, in my little tiny office, letters patent that have the floodplain reserved? If it's not reserved in the letters patent, they can't plan for it because they don't own it. Everybody should be getting their letters patent because you may or may not own to the water's edge. I also have from the Hansard something that's really cool and you're going to laugh. You know how Dalton McGuinty wanted to put the wind turbines out in the middle off the Scarborough Bluffs in the Lake Ontario? My brother had told me about 2 years ago, he has a friend who owns an airline. And he said, they can't put the wind turbines out there because they're not sure who owns the bed of Lake Ontario. I actually have that confirmed in the Hansards because the conservation authorities were not allowed to put break walls out there unless they had the permission of the private property owner because they owned the bed of Lake Ontario. I actually know another fellow that owns halfway out in the St. Lawrence River. You do not know what you own unless you have the letters patent. And now, receiving that letters patent with the floodplain reserved, what is that telling you? You see, the conservation authorities were created under the Minister of Public Works. That's right, Public Works. They were not created for all of this environmental stuff. They actually, in the Act, and it still stands today, they have to seek permission from the Ministry of Natural Resources to plant trees, because they actually have to purchase the land. And they have to seek permission from you if they want to plant trees on your private property. So if they have to get your permission to plant trees on your private property, why would you think they have the right to do anything else with your private property? The other thing that's very, very interesting is there's this thing called dedication. Now I'm going to go back to that planning meeting that I did. When I explained to the council and everyone in the room that I was considered the Canadian expert on the letters patent, the planner rolled his eyes. This is when I decided to explain to him the Planning Act. By the time I was finished, he was fully informed. Then I said to him, in that tone of a teacher to a child who has been misbehaving, I looked at him, and like a mom as well, I said, you cannot designate anyone's private property until that person has dedicated it to you by grant in deed. Now you're going, what is that? And he sat there, he turned red, he looked down because he knew he was busted, and he played with his pen. Unless you have dedicated that, unless it is registered against your title, unless you have gone through the formal process with the municipality of dedicating that land, and then they in turn accepting it and creating a bylaw to accept it, and then registering that bylaw, and assuming the maintenance of, if it's not dedicated, they can't designate it. And I would suggest, if there's any municipal councillors in the room, I don't want to know who you are, I don't care, I'm here to help everyone. Please get a copy of Grist versus Meaford, 2013. Meaford keeps appealing this case. This last ruling came down, now Meaford must pay every person who was a participant of this case $30,000 each. Go to Schedule A when you read it and see how many people are involved. Meaford has the population of maybe 5,000-6,000 people. And it's all because of a bylaw that was not passed in 1854, I think it was. They bring in the Baldwin Act, they bring in the letters patent, they bring in the original surveys, they bring in the original surveyor's notes. They go through the Baldwin Act all the way through. They bring in the Constitution of 1792. They bring in the British North America Act. It's a beautiful case. And it explains quite a bit about dedication and designation and how the process goes. If there are any councillors in the room, and for anybody else, there was another case, Jim Moyer, no relation, Jim Moyer versus Georgian Bluff. So Jim Moyer has 100 acres. The municipality has property standards bylaws. There was a complaint. Bylaw went to Jim and said, Jim, your yard is a mess. You have all of these old vehicles, so on and so forth. You got to put up a fence. And bylaw was actually being kind of nice at that point. So Jim, being very creative, and I guess Scottish, I can say that, instead of purchasing things, he went to the local businesses and he got all of their old skids and he stacked them as a fence. Well, I guess bylaw thought that this was an affront of his authority. So anyways, bylaw went and they took down Jim's fence, but they also took some of his old vehicles. Now, this is not the first time in this province, and there are a lot of court cases going on right now. But anyways, Jim sued. First case, he won, but he didn't get any real compensation, so he appealed and resued again. So the bylaw instructor was instructed by the courts that he is to know and understand the limitations of his authority. And Georgian Bluff was found guilty of trespass. And Jim Moyer is a very wealthy man now. Things are starting to turn in this province. People are beginning to know and understand, yes, you do have property rights. Anybody that tells you you do not have property rights, if you didn't have property rights, why do we have an Expropriations Act? Because the Expropriations Act does not just merely cover land being removed, and this is Antrim 2013. It also includes injurious effect to property. I can also take you to Shoppers Drug Mart versus the Minister of Health from 2011. The regulation is ultra-vires because it interferes with the property and commercial rights of Shoppers Drug Mart. You do have property rights, and your property rights are protected under the British North America Act, 1867. Don't even bother talking to me about Trudeau's Charter. As far as I'm concerned, Trudeau's Charter is a void document. According to the Canadian Bar Association in 1948, the legislators do not have the authority to grant you your rights. You already have your inalienable rights, and they are protected under the British North America Act. So now we have a document created 1982-83, and in two sections of that act, Section 1 and Section 33, your inalienable rights can be removed on a whim. Section 1 states, something that is deemed to be justifiable in a demonstrably democratic society may remove your rights. And then, of course, we have Section 33, which is the notwithstanding clause. Now, if you all think that the old constitutions don't stand and they don't matter anymore, the Métis case of 2013 brought in section, I think it was 31 or 32 of the Constitution of 1870. And that the government had dishonored the Crown by not issuing letters patents to the Métis, and the government had to. The old constitutions are not dead. They are part and parcel of your constitution today. Not only that, if you think I'm wrong, look at Section 25 of Trudeau's Constitution or his Charter, because it brings in the Royal Proclamation of 1763, which created the first four provinces: East and West Florida, Quebec, and Grenada. I bet you were thinking Nova Scotia, New Brunswick, Ontario, Quebec, weren't you? Anyways, I have to check the time. At 3 o'clock, I'm going to have a little break, and then Cindy and Jeff and I are going to be wide open for more information and questions. Please don't go away, because some of the questions are actually where you get the best information. And not only that, I'd like you all to be able to talk to each other about what you've heard so far today, and do you think I know what I'm talking about or not? Okay? So give us 15 minutes and we'll get back at it.
Just 1 second before you go. If you would indulge us for about 5 minutes, please. Just give me 5 minutes. Okay?
Niagara Landowners Association has an award to hand out today in appreciation for helping the people of Ontario reclaim their property rights. So Elizabeth Marshall, an appreciation for your dedication and passion in restoring property rights to the people of Ontario. September 21st, 2013.
So now does this mean I can keep time of all of my research and start charging for this? Thank you, everybody. This is unexpected.
Yes. By the way, the landowners are all volunteers. There isn't a paid person on the on staff or anything like that.
Wow.
And Liz did mention the patent grants. There's free applications at the back that you can pick one up and take with you to apply to the Ministry of Natural Resources to get your.
Tell them about my little books.
Oh, and Liz is that what, 17 reports?
Yeah, there are two reports at the back. I'm charging $20 a piece because I need gas money.
But there is some handouts there. There's some stuff you can purchase as well. But there is documents there that you can take with you and apply to the ministry to get your patent grant. And after the break, I'm sure Liz will expand on that.
Okay, 15-minute break, and we'll get back after questions. Thank you, 15 minutes.